understanding of intellectual property rights and the legal frameworks that protect innovation and creativity. We are honored to have with us Mr. Blaise Joseph, Assistant Professor, Department of Law, Saveetha School of Law, Chennai, Tamil Nadu, India, as our esteemed resource person. His expertise in intellectual property laws will provide us with insightful knowledge, practical application, and a comprehensive understanding of the legal aspects of protecting intellectual assets. This workshop aims to guide you through the intricate journey from conceptualizing an idea to securing ownership, ensuring that your innovation are legally safeguarded. I encourage you all to engaging actively, ask questions, and make the most of this opportunity to enhance your knowledge in this ever-evolving field. Once again, a warm welcome to everyone, and I wish you a productive and enriching learning experience. Thank you. Have a great day.
Thank you, Gayatri. I would like to invite Dr. I would like to invite Mr. Blaise Joseph, Assistant Professor. We'll continue the session, sir.
Thank you, ma'am. Thank you. Hope I'm audible.
Yes, sir. Audible, sir.
Yes, so I thank Mrs. Saranya Devi, ma'am, and thank to Gayatri and SK Group, research group of companies for giving this opportunity to share some of my thoughts and some of the content relating to the intellectual property rights as the 10th National Research Workshop on the topic from idea to ownership, navigating intellectual property law. And I welcome all the participants as well, and I hope this session will be an informative one, sharing some of the new insights to all of you. So I'll be sharing my PPT.
Yes, sir.
Give me a minute. I hope it is visible.
PPT visible, sir.
Yes. So let's begin with the very fundamentals of intellectual property law. And before beginning, let me tell that this is a huge topic, a big topic, which actually require a lot of time to explain. So my intention with this national workshop is to give some fundamental idea, some basic idea regarding to various intellectual property law, the different legal protection, and some of the fundamental idea will be concentrated to this 1 hour due to the time constraints. So, human history is a history of inventions as well. From the fire to the wheel. Today we are living in a time where artificial intelligence flourish. I want to share with you one of my experience. When I was reaching to my apartment last month, I have seen one of the kid of my neighbor is talking over the phone. So I randomly checked to this boy, to whom you are talking with. So he said, Gemini. I asked, is it your friend? So he was like, no, don't you know it's Gemini AI, an AI platform by Google. I said, how can you talk to an AI? He said, yes, you can talk to an AI. Then what you have done? Then out of my curiosity, I took the phone and I was checking. So he was just telling the AI, I got a new puppy. So it is replaying, oh, what color it is? He said brown. Then again the AI replied, brown puppies are very cute. It will be very nice. So like a human, the AI also replies to the boy. So again, I took the phone and I talked to AI. I am Blaise Joseph, friend of this boy, Midul. That is what his name. Suddenly I got a reply, hi Blaise, nice to meet you. Then he asked, what's up? I said, it's everything fine here, but it's pretty hot in Chennai. So AI replied to me, yeah, I know it is 35 degrees Celsius now in Chennai, with which feels like 38 degrees Celsius. So my point is, I was truly amazed how the artificial intelligence has now become like a friend and even influencing the small kids. If you want to create a content, it's now become an easy thing. You need not to serve so many websites. You can easily go to and find an answer in any of the ais, including DeepSeek. We have ChatGPT, Gemini, and many more. So likewise, that is the latest, maybe a kind of invention which is now very prevalent in India or in the world. So, in this fascinating world of inventions, intellectual property plays an important role. So, in fact, the intellectual capacity is something which distinguish the human from the animals. They still continue as animal, and we are progressing because of our intellectual capabilities, and we able to make a civilized state because of this intellectual capacities. So the intellectual property basically protects the inventive steps, whatever the creations of human minds. It can be an invention, it can be a literary work, or an artistic work, or a musical work, or even certain symbols, names, image, whatever, which you are creating new, then it should be protected. Then the question is why it should be protected. The first thing it is, it gives a creator an incentive. So we should be able to get the fruit of our labor, our skill, our effort, and our time. Basically, intellectual property rights protect the author, giving them an economic benefit, a fame, and a recognition. Thereby, the author will be rewarded for the work he has done. On the second hand, it encourages investments, skill, and thereby it encourages many more people to invent more. So it will accelerate the further inventions. These are the main two reasons why we need an IPR protection, and we have some more reasons. I said first it is financial profit or to gain popularity, a fame. We still remember some of the great scientists, yes or no? We still remember some of the great poet, novelist, how they gain the popularity because of their creative mind. And because of that, it become an encouragement for many people to come and invent further or express their ideas further. So that's my second point. It promotes an environment where creativity and innovations can thrive by giving such an environment where people will be encouraged for further creativity and innovations. Then third one, definitely the incentive, the monetary claims. You are putting your effort, you should be getting some reward. And these three are from the person who is using his intellect mind. But the other two are the general public. So if you want to buy a new product, a branded product, for example, Puma. So when you take a product, if you want to ensure it is a real product, you can ensure through only its trademark, that particular way of using its name. So will you be buying a product namely Puma or some other symbol? No. So you will be ensuring that it is a real product. For consumer perspective also, the intellectual property plays an important role, and it protects the businesses from that it is being misused by some other counterfeiting products or some other brands. So these are some of the basic idea or basic needs for the IP to be protected. So how the IP is important for public, why IPR should be protected, and how the society is being benefited out of the IPR regime. You can see the first step, there is an invention or a creation. So in IPR regime, it will be protected only for a limited period. For example, a patent, it can be protected only for a 20 years. Then it will come to the third phase, that is public domain. So it will be available for the public to freely use. So during the protected period, if you want to use, yeah, you definitely have to pay the money. But once the protection period is over, it comes to the public domain. When new information come, using the same, more inventions or creation can happen. So it is a cyclic process where there is a creation. After the creation, as an incentive, the IPR protect it for a limited period. Then it will go to the public domain so the public can use it free. So based on the free information, further inventions or creation will be encouraged. So that is how this IPR circle makes innovations, support people, and ultimately to benefit the public as well. So that's why IPR laws are very important. Now I move on to the different kinds of intellectual property. I want to just give the basic criteria, the basic idea about these intellectual property and how it is being protected. The entire session will be giving some basic idea of all this intellectual property. The first and foremost is patent. You know what it is a patent is. It is relating to an invention. Then we have copyright. Copyright protect your creative mind, such as a novel or a musical piece of work, artistic work, like that. Then the third one is trademark, where which helps your businesses or a product to be protected and so that no other person can copy your feature or product. Then design refers to the outer appearance of your product, the look of your product, the covering of your product. Like that again, the same purpose of design. Sorry. The same purpose of design is to distinguish your product from some other product. Geographical indications, you know, some products have certain connection with the geography from which it comes. For example, Tirupati Laddu. Tirupati Laddu having its feature because it is having some connection with the geographical area. Or the Kanchipuram sari, or the Nagpur orange. We'll deal such examples in detail. So geographical indication protects the certain goods which have certain relation with certain geographical area. Then plant varieties. Nowadays we can see certain variety of plant. In the small plant, being a small plant itself, it will give the fruits. It is through various hybrid methods, cloning methods, or breeding methods. It should be protected as an intellectual property. Then design refers to the computer parts, integrated chips, semiconductors, which is used in electronic devices. And finally, the traditional knowledge which we passes from generation to generation, and trade secret, which are certain secret for which people loves with regard to certain brands. With, for example, the taste of Coca-Cola. Whoever made a Coca-Cola, it will never comes to the same taste. The taste of KFC chicken, it is somewhat different from any other fried chicken. So there are certain secret ingredients they use, which is known as trade secret. So these are the kinds of intellectual property, the entire regime. And with that, I'll move on to the first thing, that is patents. I hope you are following. So the first intellectual property is patent, where it gives an exclusive right for the inventor from using, selling, manufacturing, and importing the patented invention. So if you found a new machine, something useful, a new invention, then you can get patented and can be protected so that you will only get the monetary benefit. No other person can use it, sell it, manufacture it without your permission. That is a basic right which is patent is being granted. So patents have territorial jurisdiction, which means if you want to get a patent protection in India, you have to file an application in India. If you want to get a patent in any other country, you have to file in that country. So if you get a patent protection in India, doesn't mean that it is valid all over the world. But now there are many international conventions where even with a single application you can apply to the various countries. Sorry, to the various countries. That is known as patent cooperation system, which is established through a treaty known as Patent Cooperation Treaty, through which with a single application you can file in n number of countries. So we'll come back to India. India, a patent is protected for a period of 20 years. And the main legislation which deals with the patent is the Patent Act of 1970, whereby the Patent Act and patent rules lay down the procedure for registration, how it should be registered, and what are the requirements for a patent to be registered. Likewise, the Act deals down the important points. So now, if you have an invention, will all invention get a patent? What are the criteria to get a patent? If you find something, you'll get a patent. No, definitely no. It should qualify certain criteria to get the patent. So these are the 4 criteria under the Indian Patent Act to get an invention to be patented. So if a patent to be invented, an invention to be patented, these 4 categories should be satisfied. The first one, it is novelty. Second one, inventive step, or it must be non-obvious. Third one, it should be capable of an industrial application. And fourth one, it should not fall within the provision of section 3 and 4 of the Patent Act. So we'll just check each criteria in detail. The first criteria is novelty. So what do you mean by novel? N-O-V-E-L. What is novel? Novel is nothing new. Novel simply means new. So novelty means if you are coming with an invention, it should not be there previously or prior. It should not be something which is already existed. Existed not alone in India, but any part of the world. So novelty means that it should be new and should not be in existence prior. The second one, your product, your invention should have an inventive step, or it must be non-obvious. So what is this inventive step? Which means there should be some technical advancement. It may not be the change of a small screw. It may not be change of some wheels. It may not be a mere change of certain parts of a previous equipment. It should be completely new and not be a mere technical change. There should be a substantial technical change when it comes to new product. Otherwise, what is the issue is, so I found some machine. 20 years, the protection will over. It should go to the public domain. So the public should be able to access on freely basis. So what I can do, I can just make some modification and I can again patent it. So again, it will be going with the protection. To prevent this abuse, the Patent Act make it important that there should be substantial change in the technology, not some mere modification will not give you a patent protection. That is what is an inventive step, where a person who is skilled in the act should not be able to predict. Whatever already existed, a person should not be able to predict this can be done. So that is what is meant by an inventive step, which should be a completely substantial change from whatever things which is being existed, and not a person in who is having skill in that particular field should able to predict as an invention. Then only it can be said that it is having an inventive step. And third one is it should be capable of industrial application. So it should not be something which cannot be achieved. Yeah, you have an idea, you have a model, but it should be able to made. It should be able to make multiple copies of the invention. That too with same result, same specification. If I make a machine, I should be able to make n number of copies of the machine with same result and same specifications. So these are the important criteria when it comes to patent. I repeat, novelty, which means it should be new, and secondly, it should be inventive step, which means it not be a mere small change with the existing thing. It should be substantial advancement from whatever is already in existence. And thirdly, it should be capable of industrial application, which means it should be able to make copies of your inventions which can give the same result or same output. Okay, and come to certain things which you cannot patent. That is a list which you can see it in section 3 and section 4. These are the things which you cannot patent. So if an invention is frivolous or obvious, which is contrary to well established natural laws, which is injurious to public health, some arrangement or rearrangement, discovery of a scientific principle, you are just discovering what is already in existence, like a discovery of a living thing or a non-living substance, or some method, some calculations, some arithmetical formulas. It cannot be patented, or a method or a computer program. These are the things which is excluded from the scope of patentability by virtue of section 3. The students kindly take the note. Section 3 says the inventions which you cannot patent. And section 4 particularly says something related to atomic energy you cannot patent. That's an exclusive area where government can only work. I hope you understood the criteria for patentability. So I'll be just giving the basic idea about registration. You have to file a application before the controller of patent. So who can file an application? Any person who is an inventor, first inventor. The term is first inventor. Who is approaching the office first? That is a first inventor. So it can be a first inventor, or his assignee can file an application in the prescribed form, that is form 1. And you have to give the specifications about your inventions. You may need to include charts and other things with relating to your invention, and a statement of novelty, and a statement that all the requirement is fulfilled. I already said before, the patent application can file by online in ipindia.nic.in. The website is www.ipindia.nic.in. You can file. So the controller will check whether it is already there and publish your invention in the official journal, so that anyone can oppose your application, being the fact that it is already in existence. So if I already invented it, I can oppose the application. And once the publication over, the examination will happen. And if it satisfy all the requirement, you can get a patent. And finally, based on the thing, the controller can grant or reject the application. These are the basic thing. Each step is so much in detail, and I think there should need some certification course, so that we can only decide. Discuss each aspect in detail, because each step is that much in detail. So with that, I wind up certain idea with patent. Now I would like to move on with copyright, and this is a term which is not new for you. I hope that you heard this big term before, that copyright, at least the symbol with a C and a round. So what is copyright and what it protects? So copyright is a type of intellectual property which protect original works. In what kind of work? That's the second point. You may have a look. It should be original literary work or a dramatic work, musical work, artistic work, cinematographic films, and sound recording. So it should be original, literary, dramatic, musical, artistic work, cinemas, and a sound recording. Okay, these are the category of works which copyright protect. And it should not be an idea in your mind. It should be in a permanent medium. You cannot simply say it's in my mind. No, whatever in your mind will not be get a copyright protection. Let it be there. It should be written or a printed medium. It should be available to the public. It should be in a permanent form. And the importance of copyright protection is it is having automatic protection. So the registration is optional. So copyright is in fact the only intellectual property which does not require a registration. It's more or there like that of traditional knowledge and trade secret. But when it comes to a formal copyright, the registration is optional, and once you publish your work, it will be automatic protected as your work so that no one else should copy the same. So that is the importance of copyright. It applies to original works. It should be original. So there's a test of originality to be get a copyright protection. Then what is an original work? Definitely it is not been part of published before. So original literary, dramatic, musical or artistic works or a cinematographic films or an original sound recording will be protected, and that too automatically protected. So you can see at the end of any movie or at the end of a TV program or something, you can see just a C with a round and writing the honor of the copyright. If I'm writing C with a round Blaise Joseph and a year, then which means I am the owner. It is published from that year. Okay, that is how the copyright protect you and automatic protection. If somebody is using, I can just file the case in a court so that my right will be protected. So who is an ownership? Who is having an ownership of a copyright? So we'll see each category and who is the owner. So when it comes to a literary or dramatic work, the author is the writer. Okay, so the writer of a dramatic or a literary work is the copyright owner. So a musical work, when it comes to a music, is it the composer? Is it the lyricist? Is it the producer? And the act says it is a composer. For the lyrics, the lyricist may have the copyright. But as a music, it is a composer who is having the copyright ownership, not even the producer. That is the difference of music with any other cinema. Because in a cinema, like we'll see, the producer is the author. And third category is the artistic work. Any artistic work, the artist is the owner who can claim the copyright protection. And for a photograph, it is the person who took the photograph. Maybe some models will be there. Maybe it's my photo may be taken, but it is not what is inside the photo or who is inside the photo having the protection. It is the photographer, the one who takes the photograph. And take a note here. Next is cinematographic film, where the producer is the owner. You may be knowing the latest sensation with Nayanthara and Nayanthara and Dhanush regarding use of certain clips or photo from the movie Nanum Rauditha, where Nayanthara and her husband had their first relationship. And when Nayanthara made the documentary, she wanted to include certain part of the scenes from the movie or from the location. But being the producer, the Dhanush is having the copyright, complete copyright, which he refused, so she couldn't use those portions. And I think he required certain amount as compensation for using it without permission. So that is the importance of cinematographic film. It is not the director; it is the producer, is the owner. But when it comes to musical work, it is not the producer; it is the composer of the owner. And lastly, when it comes to the computer generated works, it is the person who has commissioned the work. If I pay for a software, I am the owner. If I pay for some computer database, I am the owner. It's not the one who developed, but the one who pays the commission. I hope this is clear. With that, we move on. What are the rights of ownership? Yes, you have an ownership, you have a copyright. What does it mean? What right you have? First one, to reproduce the work in any material form. So you can make number of copies and you can convert it into any other form. It may be an audio recording or even a further writing, and even you can make a cinematographic film. All these make any adaptations of the work is a complete right of the copyright owner. And issue copies when they are not already in circulation. You can issue multiple copies to the public and perform the work in public or communicate it to the public. So nobody can rely on any of your work and just present it without your permission. It is only the copyright owner. And fourth one, to make a movie, a cinematographic film or a sound recording in the work. So you are making a movie out of a novel. Before making that movie, you should get permission from the owner. And you know the sensation again with Ilayaraja. Many of the time he is being in sensation. Lastly, I think with the Malayalam movie, that Malayalam movie which is relating to that Guna cave. I just missed its name. Manyumal Boys. Yeah, yeah, that's the name. Manyumal Boys, where that certain part of the music composed by Ilayaraja was used in that movie, where he claimed for compensation, and at last the producer paid some money to the composer and settled the matter. So again, if it is a copyright protected, you can't even use any part of it without the permission of the copyright owner. That is how Ilayaraja was able to sue the makers of Manyumal Boys movie relating to the same. And fifthly, to make the translation of the work. And sixth, to make adaptation of the work. And you have certain moral right. Moral right means you have the right to be acknowledged as a writer. For example, if I am using certain part of your thing, now itself I am using the name of the Ilayaraja and some other. So at the same time, I should have that liability to give the credit to them. So you should have a moral right whether you should be able to identify it as a writer or the creator of that work. That is what is known as moral right. Whatever happens, even after the protection of copyright, if it is being used, you have the right to be identified as the owner. That is simply the moral right means. So what happens if someone violate your infringe your right? And I wish to say, copyright is protected for a period of 60 years from the life death of the author. So the author lifetime of the author plus 60 year is the time of protection of the copyright. So a work, a novel will have a copyright for my lifetime plus 60 years if it is written by me. That is how the system. So Ilayaraja's works will have copyright protection 60 years even after his death. So that's the case of any creator. The entire lifetime they have the copyright plus even 60 years. For that much long is the effect of a copyright of a work, particularly a work which can get a copyright. So infringement refers to the use of a thing without authorization. So with the owner, you are using it without authorization. That is known as infringement. But there are certain exceptions. Even though it is infringement, you cannot call it as infringement. So we'll see what are the exceptions to the rule of infringement, or what all activities does not constitute a infringement. First one, the doctrine of fair use. So fair use means you are using it for some personal thing, including maybe research or criticism or review, and which you don't want to make money out of it. That is why the movie reviews are not violation of a copyright. You know, there are many YouTubers, there are many people who review, who criticize the existing works or a movie. But why they are not being punished for a copyright infringement is the reason it is comes under fair use. Okay, that is what the doctrine of fair use says. If it is for a private use or a personal use, or for a research purpose, or as a criticism or a review, you cannot be punished. Then second one, reproduction in judicial proceedings. For the purpose of court proceedings, you are reproducing any work. It is not at all a copyright infringement. Third one, for reproduction of a publication of any work prepared by Secretariat of a legislature, you know, Tamil Nadu legislature and even our parliament. These documents are already public. If somebody print or make copies of the same, it is not a infringement. But reproducing the public document is not a infringement. And fourthly, reading or reciting certain extracts in public. So I am making a speech. I'm quoting some of your works. I'm quoting certain lines. Then it is not a infringement because I'm making it in public. That too certain extracts, giving you the right. So therefore, it cannot be termed as a copyright infringement. Okay. Then, just a minute. Yes. And next is educational use. So if you are using something which is for an educational purpose or instructional purpose, then it is not an infringement. So as you know, I'm using certain pictures that I took it from the internet, web browsers, but it cannot be call it as an infringement. So that is another fair use you can make. And what if the violation? So what are the remedies if your copyright is violated? So if your copyright is violated, you have three kinds of remedy. One is criminal remedy, which means you can put the person behind the jail. You can make that person into jail. Second is civil remedy, which entitle you to claim compensation. Like the case of the Raja, you can claim compensation from the infringers. You have to get the money. And thirdly, you can seize the products which is having an infringement. So I made the copies of your works, then those can be seized. So these are some of the remedies which you can avail in the case of infringement. So criminal remedy, civil remedy, and administrative remedy. I hope it is clear. So these are some of the basic, and if you want, you can register the copyright, but it is not mandatory. If it is published, it is automatically protected. That's why I'm not mentioning the procedure for registration. So when it comes to the third category, that is trademark, I have given certain examples. These are the trademark which you already familiar. So Adidas, BBC, CNN, Walmart, or just a minute, please. Yes, thank you. So any marks which make your goods or service different from others, then it is known as a trademark. Even without name, you can see the yellow colored symbol with the red outing. You know it is the a symbol of shell, right? And the tick, maybe the cat which is jumping. These need not to say that you, without knowing the name, you know which company it is. So a trademark means it is a mark used with regards to goods or service to make those goods or service distinguish from others. So the main purpose of a trademark is to distinguish so that you can get to know it is not the same. This product is different from that. That is what the function of a mark, a trademark. So it is provided under Trademark Act 1999. I omitted to say it is a Copyright Act which deals with the copyright in India, the Copyright Act. And in trademark, we have the Trademark Act of 1999, which deals with trademark, registration of trademark, and the remedies available in the case of infringement of a trademark. So again, comes to the definition of trademark. A trademark is a mark capable of being represented graphically. So it should be a graphical representation. It should be something you can print or to show, and which is capable of distinguish. That is important. It should be able to distinguish something. What is that something? That is the second line. Goods and services of one person from those of others. So it can be the shape of goods, packaging, or even the combination of colors. So these are the things which you can see when it comes to the trademark. And to get a trademark to be protected, there are two requirements. The first one, it should be capable of represent graphically. It should be capable of represent graphically, which means it should be visible. It should be made in the category. And the second is the main purpose, which should be distinguishable from that of another. So you cannot make a trademark which is same that of some other person. Okay, same that of some other person. It should be able to distinguish. So if it is somewhat similar, then it will not get a protection. And unlike the patent and copyright, I said copyright is lifetime of the author plus 60 years. Patent is 20 years. But trademark, it is having perpetual protection. You know, a company may last for years. We cannot allow somebody else to use this goodwill. So trademark is subject to renewal in every 10 years, but it is having perpetual protection. And there are different types of trademark. Association uses a mark that is persons. Then the second category is well-known trademark. By the continuous use, certain trademark becomes so famous. KFC. Wherever you go in the world, you will able to understand. Like that of Puma or Pepsi, Coca-Cola, Google, McDonald's. I have given certain example, HP laptop or Dell. Wherever you go, any part of the world, you can get them, you can find them because it is so popular. Such marks, which is so famous among the world, among the countries, it is known as well-known trademark. When it comes to the third category, that is a certification trademark, you should have certainly heard about certain marks. For example, uh, ISI mark, ISI mark, Agro mark, 916 with regard to gold. These are certain marks which ensure the quality or service. We have an ISO certified company, which means you have certain quality according to that particular mark. But these are the trademarks which used to certify the service or the quality or some of the performance or feature. So 916 says about the quality of gold. So if it is having a 916 trademark, then you trust the quality, right? So that is the purpose of certification mark, to certify the quality, accuracy, or some other features. That is the same that of service mark. When mark is used in the field of service, then it is known as a service mark. Sound mark, where certain noise connected to a good can be trademarked. Certain replication, certain sound, certain when you press some buttons, it makes certain sound, and that also nowadays you can make a trademark. So these are some of the things I said. It is having a perpetual protection which should be renewed from 10 years in every 10 years. So with that, I uh, move on to the next things, that is geographical indication. Can you just comment what you see, the first thing, the first image and the second image? Third image, it is already there. It will be good if some of you can just respond. Is the PPT is changing? Can somebody reply? Is the PPT you can see the PPT?
Yes, sir. We
Yes.
can see the geographical indication.
Yes, thank you, ma'am. Thank you. Yes, it is a Ledu, but can you just see or just identify what kind of Ledu? I think I already said it. So that is the first thing you are seeing, is it is Tirupati Ledu, which is so famous and become sensation in recent time as well. And second is the symbol relating to Darjeeling tea. Darjeeling tea is another example of a geographical indication. And thirdly, you can see Aramula Kannadi, Aramula mirror, which is having a special taste, connected with the geography where it comes from. We'll take the example of Darjeeling tea. It is having a special taste because of the topography of that region, because of the temperature, because of the soil, because of the rainfall it gets. So Darjeeling tea from Darjeeling is different in taste or quality from any other tea. We have tea in production in different parts of the country, but Darjeeling tea is having special. So like that of Tirupati Laddu, where that geographical thing, usage of certain ingredients, the way it makes, having certain importance on the quality of Tirupati Laddu. I don't think you will get the same taste in any part of the country or in anywhere except in Tirupati. Like that of Aramula Kannadi, which is having a special one village, Aranmula, pace to end the session on time. So the geographical indication shows that this particular product originate from certain geographical territory. So it may be an agricultural product like Darjeeling tea, or a natural product like Nagpur orange, or a manufactured goods like Tirupati Laddu or a Kanchipuram silk, but it is having certain connection with the territory. So it should be having special quality, special features or characteristics with relate to the product. You may kindly see the fifth point. So the protected period of geographical indication is a period of 10 years which you can renew from time to time. Again, it is same as that of a trademark. Geographical indication is perpetual. But what is the difference when it comes to geographical indication? It is a collectively owned IPR. Not a single person can own a geographical indication because it is from a territory. It involves multiple stakeholders. That is what geographical indication says. Any association of persons or producers or any organization or an authority established by law can file an application for indication. It's not a single individual. That is the important feature of geographical indication. So the act relating with GI registered under the act, and no one else can use the GI tag. That is a feature. And if you use the act prescribes punishment as well. Punishment and the monetary compensations. Even you can claim monetary compensation. With that, we move on to the design. At the right side, you can see a Coca-Cola glass bottle or even downside you can see certain things which variety. So design means the appearance. Trademark means the name. Coca-Cola is a trademark, but that structure or pattern or both can first to the eye. Again, the purpose of the design is another. So that is what is the importance of trademark, the physical appearance, the designs in the outer appearance of a product is known as a design, which is protected under the Design Act 2000. We already said, so the design is defined as features of shape, configuration, pattern, ornament, or composition of lines or colors applied in an article. It can be either two-dimensional or three-dimensional or in both, and which may be through period of initially guaranteed for a period of 10 years, but which can be further extended for a period of 5 years. Up to totally 15 years, a design can be protected under the Design Act of 2000. So that is also about design. The design need to be registered. That is also provided under the Act. When it comes to the layout, like the pictures in the screen represent, it says the outer appearance when it comes to the chips or the integrated circuit or semiconductors. So it is something which is still developing through the development of computers and semiconductors. The mobile phones, which uses integrated chips. So the outer line of the chips are also being protected through the layout and design. So the act says the name of the act is Semiconductor Integrated Circuits Layout Design Act of 2000, where the three-dimensional 3D aspect of this particular semiconductors, metals, and IC chips are being protected. The configuration is protected, and the period of protection is 10 years. This is something a new IP which is still to be developed. And I move to the last one, that is plant variety. Now we have plant varieties through hybrid methods, two different breeding methods. With short span of lifetime, it is giving you much yield. Or even genetically modified crops, which is having, various, maybe some plants is having long life. Some plants is having certain kind to give more yield. So when you compare both, you will get a new plant variety which is having the features of both. You get me? Now we have coconut trees which may be very, very short but having more yield. These varieties are made through certain breeding methods. So the plant variety protection's primary function is to protect such inventions. So that is regulated by the Act of Plant Varieties and Farmers' Right Act 2001, established in 2001. So it gives the person who made that to sell, export, or import such good. So no one else can use it without the registered breeder's permission. But there are 4 criteria for a plant variety to get protection. The first one is again novel. We already discussed in the case of patent. Novel means new, distinct, which means it should be something can be distinguished from what is already been existed. The feature should be different. At the same time, it should be uniform. If you use it, it should get uniform and stable result. If you use a plant variety, it should be able to get the same result in every time you use. That is uniformity and stability. So the protection period is 18 years in case of trees and vines, which is perennials. So perennials means which is having a continuous life. Maybe it can be taken multiple multiple fruits. Trees, it will not end. It will continue to give the fruits. It is 18 years, but other crops or annuals. Annual means it end with 1 year or one life cycle. For example, the rice, it will end there. Once it crops given, or corn, it will not produce much. With one yielding, it will over. The life of the crop is over. Then that is known as annual, which is having 15 years. And when it comes to other varieties, that is extant variety, which means common variety, which the government notifies under the Seeds Act, which is having 15 years from the date of notification. And the Act established an authority, namely Plant Varieties and Farmers' Right Authority, and established a registry, so that in that registry you can register your plant variety. And the registry should have a national register. That's the third point you may have look, which is having a national register of plant variety, wherein the entry of the registered plant varieties have to be made. So these are the main point when it comes to plant variety. So you can register a plant variety with the registry, which is established under the Plant Variety and Farmers' Right Protection Authority. So that is all about. Then we have traditional knowledge and trade secret, but it is an area which is yet to be emerged, and there is no specific legislation to protect both. So when it comes to traditional knowledge, it is something which we follow time to time. For example, neem, turmeric. Tamil Nadu, we have a practice to mix the turmeric and pour it into the front and every day in the door or the place we come, because it is having certain therapeutic features which can kill the microorganisms, or the neem. So these are, and aloe vera. These are something which we uses from generation to generation. But somebody else, some foreign country, we have a case of turmeric where I think it's US tried to patent with the pharmaceutical benefit of the uh, uh, turmeric. We claimed it back. It's ours, which we follows from generations. So that is what is traditional knowledge, which have to be protected. And trade secret again, the secret ingredients which some product use for taste, like that of the Coca-Cola or KFC or any other things, which they have the right to be protected so that nobody else should be used. So if somebody use, you can file cases, but both of it is not being that regulated through the law. So we are coming to the last part, some emerging trends in intellectual property which require more international cooperation. And IPR is misused, like in the case of pharmaceuticals. Life-saving medicines are much costly. So when it comes to the COVID, you have seen they spent money on research and development, yes, but you cannot spend too much money on a medicine which is required for life saving. So affordability is an issue. So somebody there to abuse the IPR regime, particularly pharmaceuticals and other companies, it should be prevented. At the same time, see the AI generated contents. The AI is now being a new development. It creates content. Who wants the content of an AI? AI create a music sound. AI create an image. Who have the copyright? Is it the person who generated? Is the creator of the AI? So it is an area which is still to be developed. And the digital development. Somebody can use my photos, my works, even without my knowledge. I may not be knowing that it is being misused. So the digital development makes it somewhat impossible to check whether my right is somebody infringed or not. And the data protection. Again, the things we are giving, the data we are giving is not much protected. How can it be protected? And finally, the new forms of remedies. When it comes to the digital field, we cannot go with the old remedies, because many of the time the infringer's identity we may not know. We may not know who is the person behind where they are. So which require a new regime, a new forms of remedy. So these are some of the main point which I wanted to make you understand, and I hope you gain some of the insights. And I know it's very basic informations, but if I take each category, it will itself take each session we can discuss with. For example, if you take patent, the registration, the processes, everything will take each class. So that is why I confined my presentation to the important basic aspect. I hope you have some benefit out of it. Once again, I thank the organizers, Sharanya ma'am, and SK Group of Research Companies, and all the participants for your patient listening. So once again,
Thank you,
thank
sir.
you.
Thank you, sir. Thank you so much for the clear explanation of patent copywriting. I have one question, sir. If
Yes,
I
ma'am.
have an idea or invention, then how can I check my idea already patent?
When it comes to patent, once you file a patent application, every patent will be published. The publication serves two purpose, like you said, to check whether it is being already patented or not. Secondly, once the protected period is over, it should come to the public. The details of the invention should come to the public. That is why when you file an application of patent, every specification, every detail, the method of making the same should be submitted, and it will be published by the patent authority, which you can see it in the website as well. That is the two purpose. One, you can check whether it is already patented. Second, after the protected period, anyone can use the information as it comes to the public domain.
Thank you, sir. Thank you so much. Shall we move to the vote of thanks, sir?
Yes, ma'am. Yes, sure, ma'am.
Uh,
Sure.
Thank you. I would like to invite Ms. Soundarya, faculty, Lalani Kate Publication and Press, will deliver the vote of thanks.
Good evening, everyone. I am Soundarya from Lailaniketi Publication and Press. As we conclude the 10th National Research Workshop on From Idea to Ownerships, Navigating Intellectual Properties Laws, I extend my heartfelt gratitude to our estimate resource person, Mr. Blaise Joseph, Assistant Professor, Saveetha School of Law, Chennai. Your insights have been invaluable in enhancing our understanding of intellectual property laws. A sincere thanks to all participants for your enthusiastic engagement and to our organizing team for their efforts in the making to event to success. Thank you all for your time and contributions. Wishing you the best in your future endeavors. Thank you, ma'am.
Thank you, ma'am. Thank you, sir. Thank you for the
Thank you.
wonderful
Thank you, ma'am.
opportunity.
Thank you for the opportunity. Thank you.
Thank you.
I hope I can leave.
Yes, sir. Leave.
Thank you. Thank you,
Thank you, all
ma'am.
participants.